Thank you. My name is Michael Ratner. I'm the president of the Center for Constitutional Rights in New York, and I want to thank the Commission for holding this really critical hearing at a special moment, really, in our country, the transition of administrations, when we may actually be able to get some accountability for what has occurred over the last 7 or 8 years. I want to also thank my colleagues from the World Organization for Human Rights and the ACLU. We and other organizations have been in a long struggle now for 7 or 8 years to try and protect rights that I had assumed in much of my work in the world to be fundamental here at home as well as in the rest of the world. So it is, as I said, a very, very important hearing. The Commission has actually played a remarkable role in this whole post-9/11 world that we have in the United States. We represented the first Guantanamo detainees in February 2002. We came to the Commission quickly, within a few weeks. On March 13th, 2002, the Commission issued a remarkable ruling, saying that it shouldn't be remarkable, but it was because of the context we were in, saying that every human being had non-derogable rights, fundamental rights, no matter where they were captured, who captured them, or where in the world they were. A remarkable ruling, and also gave precautionary measures, saying that the U.S. had to hold immediate status hearings to determine the status under law, under international law, of each of the people at Guantanamo. Here we are some 7 years later, and of course the Commission's authority, legal authority, and moral authority has great weight. It has taken us since that ruling some 7 years to begin the hearings that are currently going on in Washington, D.C. That position by the Commission, as well as many others the Commission has taken on torture, on other clients of ours, have been very, very critical. And I would urge the Commission to continue in this area as petitions come to you from people who are picked up and hidden, disappeared, tortured in the so-called war on terror, to take those cases seriously as you have done and act on them forthwith, because that ruling that you gave us in March 2002 was really the first ruling by any international body to say that human beings have rights wherever they are. The new administration has actually taken some steps to get the United States off what I call the page of torture. As we know, President Obama has signed an executive order applying Army field manual techniques to all the agencies, interrogation techniques to all the U.S. agencies. That executive order is not perfect. It has loopholes, but let's even assume that it was perfect and really banned torture going forward. Let's say it did that in all cases. The problem would be, and as much as I like the picture of President Obama signing that executive order, I wouldn't like the picture of the next president signing a different executive order. And that's why accountability for violations of fundamental human rights, particularly the prohibition on torture, is so absolutely necessary. As Colleen Costello said, I am going to describe briefly some of the obstacles. You'll see them in more detail in our summaries and in the slides. One of the obstacles, which is not really a legal obstacle, would be, I would call it, a failure of will, even by the current administration at this point. And the statements coming out of the current administration really surround the terms that are stated are, we want to look forward and not backward. And I find that to be very odd, because I consider that prosecution, accountability through commissions, that range of accountability mechanisms are actually looking forward. What they are is looking forward to a country that will not again go off the page of the prohibition on torture. So I don't find it persuasive when they say we don't want to look backward and want only to look forward. I think that's a misunderstanding of methods of accountability. And I think it's important for this Commission to remind the United States of its obligations under international law to hold people accountable when they commit fundamental violations of human rights. And to do otherwise is to really grant impunity. And that would, for the United States to do otherwise, to not prosecute people or not hold a combination of truth commissions, whatever we want to call them, and prosecutions. It would violate the fundamental obligations of international law. I want to go through some of the legal obstacles. There are as I said, explained in detail. One of them is what you could call it the Self-Pardon Act or the Self-Immunity Act. That's what we call the Military Commissions Act. We've dealt with it in our papers. I'll give you a few of the ways in which it immunizes former officials from prosecution by torture. We feel that law has to be revoked. There's still a small area left where prosecutions can be had even in the teeth of that law, but that law really is barring some of the prosecutions and prosecutions as well as criminal inquiries that are necessary. So, for example, the law, there's 5 really things I can stress. One is that no person can invoke the Geneva Conventions as a source of rights. I mean, let's think about that. A major case was one in the Supreme Court a few years ago called the Hamden case that outlawed the military commissions that were being set up by the United States to try people at Guantanamo. That ruling was based entirely, really, on the Geneva Conventions and its provision that there has to be regularly constituted trials to try people. You now have a provision saying that no person can actually raise the Geneva Conventions in the court. They set up military commissions tomorrow. Under the Military Commissions Act, you can no longer challenge them on that basis. A second provision denies the right of aliens, but particular class of aliens, people held as enemy combatants or in the process of being reviewed to see if they're enemy combatants, whatever new term the new administration may have for that, denies them the writ of habeas corpus, the fundamental right, which is what really we were talking about here in 2002. As the Supreme Court held that unconstitutional with regard to Guantanamo detainees, we're still sitting there wondering what's going to happen with detainees at Bagram and other facilities that are akin to Guantanamo. Similarly, it says that aliens, similar class, enemy combatants and people under review, can't bring damage cases, reparations cases, even if they're tortured. Pretty remarkable. And what's remarkable about it is the law is made retroactive to 2001. That means that if you were tortured in 2002 or 2003, an individual cannot go into court and sue for damages under the Military Commission Act. Of course, that takes care of the civil part. There's also a narrowing of the criminal liability. We used to have a war crime statute on the book. We still do. That makes violations of Common Article 3 criminal violations. But what the Military Commission Act was narrowed it to take away numerous criminal violations that would normally have come within Common Article 3. And once again, they did it retroactively. This time they did it back to 1997. So a crime that was committed in 2003, a violation of essentially Common Article 3 of the Geneva Conventions, coupled with our war crime statute, can no longer be prosecuted. The redefinitions were taken back to 1997. And finally, and not finally because there's other holes and loopholes in this act, but they also make an affirmative defense out of legal advice that you in good faith believe allowed you to commit torture. Essentially putting into the Military Commission Act those infamous memos that were done by the Office of Legal Counsel. They say that's an affirmative defense to war crimes prosecution. So our view that one thing this administration ought to do is get rid of the Military Commissions Act. We think the role of the Commission is to talk about, as they have in prior cases, how these kind of self-immunities really are contrary to international law. The second area of obstacles occurs in litigation. And my colleague will, if you have a question about it, address particularly the state secrecy provision in the case that the ACLU brought, and that has to do with the case on renditions against the subsidiary of Boeing. And the administration took, in the Bush administration and now in the current administration, stood up in court and said, we've checked with the administration and we're continuing to take the position that this case cannot go forward because of state secrets and therefore has to be dismissed. Now, when you talk about state secrets, yes, for sure, there's a proper role for state secrets in certain kinds of litigation. But when it's used to cover up torture and extraordinary rendition, I don't think there's a proper role for state secrets. Likewise, in a series of cases brought by a number of organizations, including my own, around civil cases for torture, one called Rasul v. Bush, Guantanamo detainees suing Bush as well as Rumsfeld and others for torture at Guantanamo, the IACHR case, the Canadian citizen who was tortured in a underground cell in Syria. Those cases, the past government, and particularly in Rasul v. Bush, the current government has come into court and say people who we've sued should have qualified immunity, that the law was not clearly established that you couldn't torture someone or send someone to torture when this happened in the last 7 or 8 years. I just think that makes no sense, and it's another block. So the U.S. position in litigation has actually held back and is holding back in the past administration and the current administration accountability. Another point on this I just want to mention briefly is statutes of limitations. This actually needs to be pressed fairly rapidly and fairly quickly. The statute of limitations of the anti-torture statute is 8 years. Some of these people in the secret sites were suffocated by water, as the Red Cross says, or waterboarding, in 2002. We're talking about a year and a half to continue to get prosecutions under the anti-torture statute. That means we either need immediate investigation and prosecution, or we need a tolling of that statute or an extension of that statute. That's just one example of the problems we're beginning to run into as time goes on. I can go into more of those obstacles, but that gives you a sense of some of the obstacles that we who seek accountability are facing as we go forward in the United States. The second area I want to briefly address is accountability mechanisms. Those are slides 19 to 22. We've taken the position at my office, and a number of other human rights organizations have taken it as well, is that criminal investigations and prosecutions, if warranted, are indispensable no matter what other mechanisms are employed. They deter, and they're the really only deterrents for future human rights violations. That's the way in which you can demonstrate that those violations will not be tolerated and they will not be repeated. They provide justice to the victims, they punish the offenders, and otherwise what you're faced with is impunity, impunity, and impunity, and a future where abuses will again be repeated. This is not to say that there's no place for whatever term you want to use, presidential commissions, congressional commissions, hybrid commissions, truth commissions, commissions of inquiry. Yes, there's a place for those. I understand they can play a role and an important role for survivors to give their stories, for truth, and for reform. But I don't think, and I think this commission has said it before, they can't be used as substitutes for civil and criminal liability, and they can't be used to forestall or minimize cause for criminal liability. And if we're going to use a commission in any way in the United States, I think it has to have certain criteria. One is that criminal liability has to be out front. A commission can't be used as a way of hiding criminal liability. I think secondly, it has to have the authority to refer evidence and cases to a prosecutor. Thirdly, it can't grant immunity. It can't protect people, particularly the higher-ups, in the name of getting the truth and therefore let them out. And fourth, I think a prosecutor has to be involved. Otherwise, a truth commission, commission of inquiry, whatever you call it, can make decisions that will ultimately redound to hurting and harming prosecution. The one commission that's been bandied about a lot now in the United States is the so-called Leahy Truth Commission. If you look at that, that fits none of those criteria. It's one that will give immunity. It's one that they have said will expose the, quote, truth and turn the page. That's not what we need. We need both truth and we need prosecutions. So as I talk about accountability, I think it's important for this commission to say, yes, you have to get to the truth. Commissions have a role, but no, you can't reject investigation and prosecutions if warranted. In closing, I want to say we're at a crucial juncture really here in the United States. We're at a point in which this commission and in which this country can emphasize that the laws against impunity apply to the big countries and not just the small countries of the world. And that this commission, and I hope really the next administration, will disavow what has really been the unwritten understanding in this country, that crimes committed by the United States and a few other Western countries will go unpunished. So thank you for your attention, and I now turn for a summation to my colleague.
You've been wanting to say this
That's
for
right.
a long time.
Lock them up. Lock them up. Lock the bastards up and throw the key away. Far away! A few years down and get Mo, then life in Abu Ghraib. Make sure their sorry asses never see the light of day. Think you got it? 2, 3, 4. Lock them up. Lock them up. Lock them up. Lock them up. Lock the bastards up and throw the key away. Far